Please be seated. వాళ్ళు మిమ్మల్ని రాంగ్ కంప్లైంట్ చేశారా? I was informed that practicing certificates are heavy. Easy. Now it is 3:58. బట్ చెప్పే సబ్జెక్ట్ మీకు ఏం అర్థం కాదు, గోడగట్టని ఉంటుంది. ఏం అర్థం కాదు చెప్తున్నా. మీ డైరెక్టర్ గారు రికార్డ్ పర్పస్ కోసం పెట్టుకున్నారు. I think so. Yes, corruption facts. Now I want to discuss not only with you. Somebody is there and say, I think it is recorded and they will keep as a record. Okay. Normally, as already discussed, suit will be filed. The defendant will file his letter statement, counterclaim or set off. Issues will be framed. Then the plaintiff will examine his witnesses. The defendant will examine his witnesses. Then, after hearing the arguments, the court will pronounce the judgment. But the important aspect here is, for conduct of trial, there are certain important aspects that we should consider. There are certain important aspects that have to be considered. Let us discuss. We will call it as a hurdles. You may permit me, please can permit me to use the word hurdles. Because I am a resource person in several workshops that are being conducted by the Honorable High Court. Okay. Then I will take permission from the chair, that is the portfolio judge concerned for the question, and we'll discuss certain important aspects. See, what the law says, the defendant is having a right to cross-examine the witnesses. Very right. The law is also to the effect that the defendant counsel can put leading questions. The plaintiff counsel cannot put leading questions. Only the counsel for the defendant can put leading questions. He can elicit. Now here important question here is, I will take a small example. See, it is a specific purpose or agreement of sale, alleging that both D1, D2, D3, all the three have executed agreement of sale in my favor, and D1 to D3 all receipt of 10,000 rupees each. Executed agreement of sale. This is the agreement of sale. That is the case of the plaintiff. Plaintiff. D1 has filed a letter statement stating that I have not received any rupees 10,000. I have not received 10,000. I have not executed any document. Number one, D1. Number two, I have executed the document. But I have not received rupees 10,000. D1 has received 10,000 rupees on my behalf. D3 has filed a statement containing that, yes, I have executed the document. I received 10,000 rupees. D1, D2, D3. D1, total denial. D2, admission with regard to the execution of the document and the reception of the document. 10,000 rupees is by the D1, D3 source. Now PW1 is in the box. Who has to first cross-examine? Everybody will say, sir, D3 has to first cross-examine because D3 is sailing with the plaintiff. Friends, I want to tell you, Under Section 137 of the Evidence Act, Indian Evidence Act, only the adverse party can cross-examine, can put leading question. Here, who is adverse party to the plaintiff? D3 has no adverse interest to that of the plaintiff. Okay? D3 has no adverse interest. D2 has adverse interest to the effect that I have not received 10,000 rupees, the D1 has received 10,000 rupees. So, receipt of the consultation, to the effect of receipt of consultation, the D2 is the adverse party to the plaintiff. D1 is adverse party to the plaintiff. He has denied everything. Now, as per Section 137 of the Evidence of Old Act, Kota Act, Section that Prakaram, D3 has no right to cross-examine the plaintiff. D3 has no right. D2 is having a right to cross-examine the plaintiff to the effect of receipt of consultation. He can put leading question to that effect if they got to the receipt of consultation of the 10,000. D1 can tear the plaintiff into pieces. He can cross-examine in all aspects. He can put leading question, he can cross-examine. That is the important, one of the important aspects. Even last month in Karnool, 2 months back in Karnool, then in Anandapur, I have stated the senior officers or senior advocates are still there, they say, supporting the very must cross-examine. There are a number of decisions in this aspect. పెద్ద కష్టం కాదు, నేను డైరెక్టర్ గారు కూర్చోమని చెప్పారు కాబట్టి నేను కూర్చున్నాను. ఐ నో ఇట్. See, AR 1978 AP 193, AR 1978 AP 193, AR 1978 Punjab Haryana 319, AR 2002 Calcutta 235, AR 1981 Gujarat 190. In all these judgments, the Lordship of various high courts held that the defendant who is sailing with the plaintiff is not entitled to cross-examine. That means D3 is not entitled to cross-examine at all. D2 only to the particular extent. D1 cross-examine. Actually, this is for me, this is a half-hour class for me. Now, not necessary because only for record purposes they are recording. Okay, that is one important. Another important aspect is already we have discussed in the morning. Under Article 38 Rule 5, we can attach the property before judgment. Article 38 Rule 5, we can attach the property after due notice. Notice must be what 38 says. 38 Rule 5 says a notice must be given. If notice is not given, the attachment is void. Notice, after giving notice, the attachment was effective. Then the defendant makes their appearance and filed undertaking affidavit. Filed an undertaking stating that, sir, I don't alienate the property. I don't alienate the property. Hence, attachment will be raised. Why? Because in the villages, immediately after attachment, there will be a tom-tom in the village. Palani vaadu, Palani court varu attach chesinar. It's a prestige issue. It's a prestige issue, attachment property. Palani Reddy Gardo, Sahibu Gardo, attach chesinar. Then they will file an undertaking of it, facing an affidavit. If the court raises the attachment, again there will be a tom-tom. Thrice in the village. Yeah, court varu ittaru teesesinar, ichesar. Now the question is whether court can accept the undertaking of it and raise the attachment. In 2016, Volume 5, ALT 363. 2016, Volume 5, ALT 363. Wherein the Lordship held that such an affidavit cannot be taken and attachment, basing an undertaking of it, the attachment cannot be raised. But my humble view is, amounts to attachment. Undertaking affidavit filed by the party amounts to undertaking. Attachment. What section 64 says? Any attachment by private, after attachment, private alienation is void. Section 64 says. Here, suppose after giving undertaking, if the party alienates the property, he may argue there is no attachment, isn't it? The party may argue, sir, there is attachment, hence I have sold it. But it amounts to attachment. It amounts to attachment. It amounts to violation of the court order. 39(2)(a) applies. What is the section 39(2)(a)? Suppose there is any violation in respect of the interim injunction passed, the JDR, the respondent will be punished under 39(2)(a). Then Volume 3 ALT 746, 2000 Volume 3 ALT 746, wherein held it amounts to, undertaking amounts to attachment. Then it also amounts to contempt, because he has given undertaking to the court. It amounts to contempt. 2004 1 SCC 360, 2004 1 SCC 360. It is punishable section 39, section 39(2)(a), section order 39. Sorry, order 39(3)(a). That amounts to, that is punishable. 1996 Volume 2 ALT 4. 1996 Volume 2 ALT, page number 4. In another judgment in AR 1996, SC 1293, SC 1293, wherein the lordship held that is a part, attachment is a part of the decree. Okay. మీకు అర్థం కాదు, మీకు టెన్షన్ అవుతుంది. ఫర్ సమ్ టైమ్ రికార్డ్ పర్పస్ కోసం మిమ్మల్ని కూర్చోబెట్టారు. ఐ నో ఇట్ వెరీ వెల్. బట్ లీవ్ ఇట్. దెన్ నార్మలీ in trial, the party has to get into the box first. Then the party will examine other witnesses, say plaintiff. Plaintiff will be examined as PW1. He will examine PW2, PW3, PW4. Then defendant, suppose sole defendant will depose as DW1, DW2, DW3 examine. Now the question here is, what the law says, sir? What the law says? Order 18 Rule 3A says. So if for any reason party is not examined at first instance, he can be examined at later stage. But after obtaining the permission from the court, so if normally plaintiff as PW, he must get into box. He failed to, for some reason or other, he failed to get into the box. Now the question is, now he has examined other person as PW1, other person to PW2, PW3. Now the plaintiff wants to get into the box as PW4. Whether he can get into the box as PW4, that is important. The question here is, yes, he can get into the box after obtaining the permission. After obtaining the permission, he has to file a petition. Sir, for a particular reason, I could not get into the box. Hence, I may permit to get into the box. If the court feels his request is proper, then he can be examined. Now, here the question is, before examining the other witnesses, he has to file such an application, or after examining the other witnesses also, whether he can file an application. The view of the several officers, several advocates, that first he must obtain permission from the court, then he has to examine the witnesses, then later only he has to get to the box. No. Take it from me. No. He need not obtain prior permission. He can obtain permission subsequently to get into the box. Suppose, example, two witnesses are leaving India and they'll come back after 5 years. It's a good reason, sir. It's a good reason. He can file application. But everybody feels that you must take first permission, then only you must examine the witnesses. It's not correct. 2018 Rule 3A is important provision. 2012, Volume 2, ALT 604. I brought all the citations. In fact, I wanted to explain, suppose the practice advocates are here. I want to examine, I want to discuss with them all the judgments. I brought the judgments also. But there is no audience to question me. Right? So, 2012, Volume 2, ALT 604. 2013, Volume 4, ALT 595. 2013, Volume 4, ALT 595. 1994, 3 ALT 425. 1994, Volume 3, ALT 425. Supposing the defendant, again for him also, our 18 Rule 3 applies. Then 1993, Volume 3, ALT 182. 1993, Volume 3, ALT 182. Then another important aspect, because I got time, I have to, double with Vande Bharat with double engine. Okay, what? Have you heard the word rebuttal? Perhaps this is not stage. Rebuttal evidence. Suppose under Article 14 Rule 2, the court has to give findings on all the issues, isn't it? Then have you heard about the burden of proof? Burden of proof. Who has to prove certain fact? Suppose on Section 118 of the NI Act, if once the party has admitted the negotiable instrument, that is a promissory note, let's say easy, the presumption is consideration passed. Once the document is admitted, negotiable instrument is admitted, say, suppose the plaintiff has a filed suit based on a promissory note, alleging that defendant borrowed so amount. If the defendant admits, yes, I have executed the promissory note, but I have not received the consideration. So in view of Section 118 of the NI Act, burden is on the defendant to prove that no consideration is possible. Similarly, in a partition suit of a joint family property, the party who contends that particular piece of property is by self-covered property, he has to prove it. Say A, B, C properties are there. The suit is filed for A, B, C properties. Suppose defendant contends, sir, C property is by self-covered property. Now, a భార్య అలా కట్టం తీసుకొచ్చింది, ఆ కట్టం పెట్టుకున్నాను. But burden is on the defendant to prove that it was his self-acquired property. The joint family is no way concerned with plain scheduled property. Okay, so what the presumption under Hindu law is that the family is joint unless and until it is proved that there was a division. There is a presumption. So there is a division. Similarly, joint family property means joint family owning some properties. There is no similar presumption directly, but defendant has to prove that it's plain scheduled properties. Suppose presumption. Suppose in certain circumstances there are 4 issues. With respect to the 2 issues, the burden is on the plaintiff. In respect to the 2 issues, burden is on the defendant. So the plaintiff is not supposed to lead. He can refuse to lead evidence in respect to 2 issues where the burden is on the defendant. So he can lead evidence with regard to 2 issues where the burden is on the plaintiff. Then he can reserve right of rebuttal. Sir, all the defendant get to the box in respect to 2 issues. Then I will examine my witnesses with regard to that. That is what is called right of rebuttal. Right of rebuttal. So normally Memo will be filed. Sir, I have read the evidence in respect of issue number 1 and 2. I am reserving the right to examine the witness in respect of 3 and 4. I am reserving the right of rebuttal. They will file a memo. That memo should be recorded by the court. Then, after examination of the defendant's witnesses in respect of the issue so and so 3 and 4, again the plaintiff will get an opportunity to examine the witnesses, his own witnesses in respect of other 2 issues. That is right. That is what is called right of rebuttal. Okay, right of rebuttal. Okay, right of rebuttal. Suppose if the counsel has not filed for some reason or because of the inexperience or because of the negligence, whatever it may be, he has not filed a memo reserving his right of rebuttal. The question is now, can he get into the box, say again, sir, I have examined only my witnesses only with regard to 2 issues. I want to examine with regard to 2 other issues. Since he has not reserved his right of rebuttal, the question is whether the plaintiff is entitled to produce evidence. If there is the right of rebuttal is reserved, then he is entitled. But number of judgments are there. 1986, Volume 2, HCL High Court Notes 5-3. 1991, Volume 3, ALT 285. 1991, Volume 3, ALT, Andhra Law Times 285. 2012, Volume 3, ALT 278. I will permit to repeat it. 2012, Volume 3, ALT 278. Let us jump next. Injunction, a suit is filed for particular relief. Injunction, a suit is filed for particular relief. A petition is also filed for grant of interim injunction. I will permit to repeat it. The plaintiff has filed a suit for some relief. Relief is not important now. He also filed a petition for grant of interim injunction to restrain the defendant, whatever it may be. Now it is the contention of the defendant that suit itself is not maintainable. The contention of the defendant respondent is that suit itself is not maintainable. Whether such a plea, such a contention can be considered at the stage of interim injunction petition. I may permit to repeat it once again. The plaintiff has filed a suit for a particular relief. He has also filed a petition for grant of interim injunction. In the interim injunction, the plea of the defendant is that suit itself is not maintainable. Hence, no injunctions can be granted. That is the plea of the defendant. Now, whether is it the duty of the court to consider the maintainability of the suit at the stage of order 1 and 2 injunction petitions? What the law says. Normally, maintainability of the suit need not be considered at the stage of inquiry with regard to the order 1 and 2 petitions. But, as already stated, suppose a petition is filed, a suit is filed for recovery of the damages in an accident. The court is not having inherent jurisdiction. Junior civil judge is not having inherent jurisdiction to entertain a suit with regard to the damages that caused because of the injuries. So, such a suit is not maintainable in your section 9. There is a bar. Straight away on the face of it, if the court feels that suit is not maintainable, if the respondent defendant satisfy the court that the suit is not maintainable because of this, then that should also be considered. In all normal circumstances, such a contention of the defendant need not be considered. 2016, Volume 4, ALT 443. 2016, Volume 4, ALT 443, Division Bench. Another important aspect to consider is the plaintiff has filed a suit for particular relief. The plaintiff has also filed for a petition for grant of injunction. Now the question is, in the same suit, whether the defendant can ask the injunction against the plaintiff. I may permit to repeat it. A suit is filed by the plaintiff for a particular relief. He has also filed an injunction petition against the defendant. In the same suit, whether the defendant can ask injunction against the plaintiff, but in injunction, can he file? Yes. ఎక్కడ చెప్పరా తల్లి? Yes. How yes? Why yes means what is meant by why, what is meant by e, what is meant by yes. 39 తీయండి ఒకసారి, 39 CPCలో ఒకసారి 39 తీయండి. 1 కిందికి రామ్మా, నువ్వు సెక్షన్కి రా.
Cases in which temporary injunction may be granted, where in any suit it is proved by affidavit or
Slow,
otherwise.
be slow. Sir, నేను చాలా స్లో సార్. Weak.
Where in any suit it is proved by affidavit or otherwise
Yes.
that any property in dispute,
Any property, important word. Any property is important. Next.
in dispute in a suit is in danger of being wasted,
Yes.
damaged or alienated by any party to
By?
the suit. Any party to
Any
the
party means
suit. Defendant.
he may be defendant. Any party means he may be defendant. The plaintiff, okay. By any party, defendant can also file such injunction petition against the plaintiff. వచ్చిందా? కిందికి రా. నెక్స్ట్ క్లాస్
Or wrongfully sold in
అదంతా
execution,
నెక్స్ట్ క్లాస్కి రమ్మా.
that the defendant pretends.
That the defendant. So, only plaintiff can claim such a relief. In respect of the class B, na?
B, sir.
B. C చూడండి.
See, that the defendant threatens to dispossess the plaintiff.
Defendant. All defendant. Again, the plaintiff is not entitled. A defendant is not entitled. Only plaintiff. Next.
Next, the court may order grant a temporary injunction.
Right, leave it. So, my question is, when it comes under the one, defendant can also file injunction petition against the plaintiff. Okay, by any party. Right, sorry. That there are a number of decisions in respect of this. K. Jawahar Reddy versus G. Kamala Rao. K. Jawahar Reddy versus G. Kamala Rao, 2008, volume 6, ALT, Andhra Law Times, 772. Singaluri Krishnamurthy versus Singaluri Damodar Rao, 2010, volume 3, ALT, 777, అక్కడ లేదు 377. Their lordship of High Court held that in view of 39(1)(a), the defendant can also file injunction. That's clear. The provision is very clear. Suppose there are 1, 2, 3 defendants. 1, 2, 3 defendants. Whether D3 can file such injunction against D1?
Yes.
Any party.
Any party.
ఇది వచ్చిన ఒకసారి ఇంటర్లాక్డ్ అప్లికేషన్స్ ఏలూరులో చెప్తున్నాము. ఈ క్వశ్చన్స్ వేస్తే అంత వాళ్ళు ఆఫీసర్స్, జ్యుడిషియల్ ఆఫీసర్స్ నన్ను పిక్చర్ చూసిన వాళ్ళు చూశారు. నేను ఎక్స్పెక్ట్ చేశాను వాళ్ళ చిరునవ్వు చూసి. ఐ ఆన్సర్డ్ ఇట్. యూ ఆన్సర్ మై క్వశ్చన్. ఐ గేవ్ సైటేషన్స్. Later they appreciated me. That's a different matter. Okay, suppose can file against D2, D2 can file D1. That is 2005, volume 1, CCC, Civil Court Cases, 76 Kerala. 2005, 1 CCC, 76 Kerala. Okay, now the important aspect I want to bring to guide notice is about 2 years back, an officer called me on phone stating that, sir, the injunction petition is filed, but my learned prisoner, instead of granting injunction, appointed a commissioner The prayer of the petitioner is, plaintiff is, to grant interim injunction. But instead of granting interim injunction, my learned petitioner has passed receiver or commissioner. Whether such an order can be passed. There is no prayer. Whether such an order can be passed. He said, no, my learned petitioner has committed a mistake, sir. How to rectify it? He said, who said it is a mistake? Again, 3912 count. చదవ మరి కిందికి రా. By any order ఉంది చూడండి దాంట్లో 39 తీనాం.
The vote made by order.
Makes such an order. Such an order means any order. నీ ఇష్టం వచ్చింది. But it must be according to law. Such an order includes appointment of commissioner, appointment of receiver. It is not my word. నేను చెప్పింది కాదండి. నేను చెప్తే ఎవరు వినరు. రవి లక్ష్మయ్య వర్సెస్ నాగమోతు లక్ష్మి. రవి లక్ష్మయ్య వర్సెస్ నాగమోతు లక్ష్మి. AR 1971 AP 380. AR 1971 AP 380. Such an order can also be passed at the instance of the defendant. Already we have discussed. That is 2004, Volume 5, SCJ Supreme Court Cases Judgments. 2004, Volume 5, SCJ 162. Okay. Then another important aspect I want to bring to your kind notice is that, let us take once again the simple promissory note. Defendant has filed a suit basing on a promissory note. The plea of the defendant is that the document is rank forgery. Now, defendant wants to send the document to an expert. What is the appropriate provision? I am permitted to repeat it. The defendant wants to send the document to an expert. Then what is the correct provision to send the document to an expert? Everybody says Section 40 of the Evidence Act. Everybody says Section 40 of the Evidence Act. What is Section 40 of the Evidence Act? Pathadi, kotta section undi dantlo. Huh? ఏముంది కాదు తల్లి the normally under Evidence Act, opinion evidence need not be considered. It is not admissible. Opinion evidence is not admissible. But Section 45 is an exception to the general rule. What is Section 45? The opinion of the expert is admissible. So, officers or advocates are regularly filing a petition in Section 45 of the Evidence Act. That's not correct. నేను రాజమండ్రిలో చెప్తుంటే హైకోర్టు జడ్జి గారు అంతకుముందు ఒక జడ్జిమెంట్ చెప్పారు దీని గురించి. దెన్ ఎక్స్ప్లెయిన్ ఇట్. ఆర్డర్ 26 రూల్ 10 చూడండి. ఆర్డర్ 26 రూల్ 10 10A.
Commissions for scientific investigation.
ఏముంది చదవమాయి.
Where any question arising in the suit involves any specific investigation which cannot, in the opinion of the court, be conventionally conducted
Yes.
before the court.
Yes. ఇప్పుడు చెప్పండి. Scientific any opinion given under Article 26 Rule 5, 26 Rule 10, that opinion is relevant to Section 45 of the Evidence Act. Everybody is writing Section 45 of the Evidence Act. Opinion given under Article 26 Rule 10 10A is relevant under Section 45 of the Evidence Act. Similarly, under Section 75 of the CPC, subject to such conditional limitations as may be said, the court may issue a commission to examine any person, to make local investigation, to examine or adjust accounts, to make partition, to hold a scientific, technical, expert investigation. Is it clear? The party must or the council must file petition section 75, read with Article 26, Root 10 DNA. Everybody is filing section 45, section 45. The opinion given, I may permit to repeat, the opinion given by a commissioner who was appointed on 26, his opinion is relevant on section 45 of the Evidence Act. 45 is not there. Second aspect is music out of the
section 45 only criminal cases.
ఎవరు చెప్పారన్నమాట సెక్షన్ 45 చెప్తారా క్రిమినల్ కేసెస్ అని చెప్తారా
లేదు సార్ అంటే నా డౌట్ లైక్ సెక్షన్ 45 ఓన్లీ క్రిమినల్ లోనే వాడాలి
నో ఎవిడెన్స్ యాక్ట్ అప్లైస్ బోత్ సివిల్ అండ్ criminal then as already stated opinion evidence is not admissible. Section 45 of the Evidence Act is relevant. Now new section is section 39. Now new section is section 39, which is 45 earlier Evidence Act. So the opinion given by an expert is relevant. A chapter relevancy of the evidence chapter that way. Okay, right. Now the question, another important aspect I want to bring to your notice is, have you heard about the contemporary signatures? Contemporary signatures. అంటే ప్రామిసర్ సంవత్సరాల కింద ఎగ్జిక్యూట్ చేశాడు, సిగ్నేచర్ మారుతూ ఉంటుంది. నా సిగ్నేచర్ ఎవరికి అర్థం కాదండి, ఏంది డిజైన్ గీస్తా, సంవత్సరాలు మీకు గీసినట్టు గీస్తా, బట్ ఒరిజినలీ మై సిగ్నేచర్ వాజ్ డిఫరెంట్. ఇయర్స్ పాస్ అయిన తర్వాత సిగ్నేచర్ మారిపోతుంది, న్యాచురల్. ఇప్పుడు 10 సంవత్సరాల కింద ఎగ్జిక్యూట్ చేసి డాక్యుమెంట్ ఎగ్జిక్యూట్ చేసి ఇప్పుడు సిగ్నేచర్స్ పంపించి నువ్వు కంపేర్ చేయవాయా అంటే ఎట్లయింది? సో ది కోర్ట్ ఆర్ ఇన్సిస్టింగ్ కాంటెంపరరీ సిగ్నేచర్స్. కాంటెంపరరీ అంటే 10 సంవత్సరాల కిందట ఈ కాగితం కాకుండా ఇంకేదైనా కాగితం ఉందా, ఒక డాక్యుమెంట్ ఉంది, ఈ డాక్యుమెంట్ మేము కంపేర్ చేయాలా, ఆ పీరియడ్లో ఒక సంవత్సరం ముందో ఒక సంవత్సరం తర్వాత ఏదైనా సిగ్నేచర్ డాక్యుమెంట్ ఉంటే దాన్ని కంటెంపరరీ సిగ్నేచర్స్ అన్నారు. అది షుడ్ బి ఫైన్. బట్ వాట్ లా సేస్, is it mandatory that contemporary signatures are necessary? Who has to give his opinion? He is the expert. ఈ సరిపోద్ది ఈ సిగ్నేచర్, నేను ఒపీనియన్ ఇవ్వగలనా లేదా అని చెప్పాల్సిన సైంటిఫిక్ నాలెడ్జ్ ఎవరికి ఉంది? ఓన్లీ ఎక్స్పర్ట్ ఈస్ హ్యావింగ్. బట్ దెన్ వాట్ ఈస్ ది ఎవిడెన్షియల్ వాల్యూ ఆఫ్ సచ్ ఒపీనియన్ గివెన్ వితౌట్ కాంటెంపరరీ సిగ్నేచర్ ఇస్ డిఫరెంట్. 10 ఏళ్ల సంతకానికి, నేను రాత్రి చేసిన సంతకానికి కంపేర్ చేసి ఆయన రీజన్స్ ఇవ్వగలిగితే, ఇఫ్ ఈ ఫేస్ cross examination, if satisfies the court that yes sir, yes these are the reasons, for the following reasons of the opinion that the signature that was in disputed signature or the admitted signature is only to say, who has to give such an opinion? The expert has to give, not you and me. I do not know. No doubt the court is having power to compare the signatures. I used to advise my officer, you are not an expert to compare. You are not an expert to compare because you are not having any scientific knowledge how to investigate. So better to send the document to an expert. Then at what stage, number of citations are there, at what stage, అన్ని అవకాశాలు అనుకొని జడ్జిమెంట్ చెప్పే రోజున అవుట్ ఆఫ్ ఆర్డర్ వేసి సార్ డాక్యుమెంట్ పంపిస్తానంటే ఎవరైనా ఒప్పుకుంటారు? కోర్టు వారు ఒప్పుకోకూడదు కూడా. Delay in filing such an application is fatal. Number of citations are there. And here the question is, suppose, as already stated, an opinion is given by an expert basing on the signature that was made subsequently after 10 years. Then the commissioner, expert commissioner, will use the box to cross-examine him. Pen pressure, wonders, land, all considerations ఉంటాయి. ఫోర్జరీ చేసేవాడు ఇట్లా ఫోర్జరీ చేస్తాడు, సంతకం పెట్టేస్తాడు. పెన్ ప్రెషర్, స్లాంటింగ్, ఎల్ ఉంటుంది కదా, ఇట్లా ఒక స్ట్రైట్ పెడతారు, సొట్టగా పెడతారు. స్లాంటింగ్, there are several considerations. ఇది కూడా అనుకుంటాను, ఇది కూడా మీకు దీంట్లో డీటెయిల్ నోట్స్ రాశాను. సపరేట్ ఇట్స్ 3 hours క్లాస్ ఫర్ మీ, సపరేట్ బ్రీఫ్ నోట్ ఆన్ రెఫరెన్స్ టు డాక్యుమెంట్స్ అండ్ ఎక్స్పర్ట్ or and appreciation of experts' evidence. Separate, to the best of my knowledge, I gave it in the office. You can collect it necessary. If it's not there, ask your director to call me and send it. Okay. So here, contemporary signatures lekunda opinion ఏదైనా చెబితే what is the effect of it? Yes. ఎందుకంటే సచిన్ టెండూల్కర్కు ఒక ఓవర్ని 20 రన్లు చేయాలా అని అట్లా స్పీడ్ ఉంటుంది నాకు. ఉండేది ఒక ఓవర్, దానికి 20 రన్లు చేయాలా. ఉండేది నాకు 20 నిమిషాలు టైం, 20 నిమిషాల్లో నేను సెంచరీ కొట్టాలా, కూడా టాపిక్స్ అయినా కొట్టాలి. బికాస్ ఐ హ్యావ్ టు లీవ్. దెన్ we have already discussed about receipt, section 46. No, need not. Then we have also discussed under 39, section 39(4), decree cannot be executed against a personal property who is outside the jurisdiction of the court. We have already discussed 2148, 2148A. We have also discussed that is Salem Bar Association versus Union of India. Okay, right. We have already discussed it. Okay, whether the caveat petition is maintainable in respect to the execution petitions, whether the caveat petition is maintainable in respect of the execution application. Sir, I am judgment data. The decree holder may file execution application. Hence, give me notice. I am filing section 148 petition. Whether such a petition is maintainable in execution. Because the JDR is not having any right to receive the notice. JDR is not having absolute right to receive notice. What 912 says, shall, the word shall is used. The court shall issue notice. Notice is mandatory there, but already stated reasons must be assigned, then you can grant alternative injunction without notice. But when coming to the execution, no such procedure is there. The JDR is not entitled for notice as a matter of right. Only particular LRs are filed. So it's after 2 years filed, notice is mandatory. So caveat is not mandatory. Number of citations are there. Okay, I'll give you my notes. Then another important aspect is this one is filed for particular relief. The petitioner has also, the plaintiff has also filed a petition for grant of interim injunction. Only interim injunction. What is meant by interim injunction? What is meant by perpetual injunction?
Interim injunction is for a particular period.
What is meant by perpetual injunction? Don't do it. Do it? Mandatory. Thank you. Don't do it, perpetual injunction. Do it, mandatory injunction. But the suit is filed for permanent injunction only. Whether without a prayer, whether the civil court can grant mandatory injunction against the defendant. The prayer is only for permanent injunction. The court has granted mandatory injunction that the defendant so also do so also. Whether such a order can be passed. Yes, can be passed. Because suppose, knowing fully well there is an injunction order, some constructions were made, then the court can ask the defendant to demolish the building. Yes, it can, the court can order. But you cannot argue that the suit is filed only for partial injunction. But because there are some illegal constructions, again, whether the party has to file another suit for mandatory injunction or demolition, all these things are not necessary. Okay, 2004, volume 4, ALT 765. 2004, ALT 765. wherein the lordship held such a mandatory injunction granted. Have you heard the word court witness? Have you heard the word court witness? Normally, the plaintiff will examine, the plaintiff witness is PW1, defendant will examine, defendant as DW1 or DW2. Very.
Court witness.
ఎక్కడ ఏ సర్కమ్స్టెన్స్లో వస్తుంది కోర్ట్ విట్నెస్? Whether court can examine his witnesses, his witness, the plaintiff PW1, defendant DW1, plaintiff court. Suppose Order 6 under Order 16 Rule 14, the court can examine any witness. Court can examine any witness. Suppose the plaintiff or the defendant have not examined a particular witness. If the court feels the evidence of the particular witness is necessary, the court can examine that particular person as a court witness. In that 16.4, the court can examine a particular witness as a court witness.
Court may on its own motion
Examine. Now, another important aspect I want to bring it to a kind notice is whether court can examine a particular witness on the request of any party.
Yes.
See, what the court will do, if the court feels 1614 says, the court feels examination of a particular person is necessary, then he can be examined as a court witness. Now my question is whether can the party ask either the plaintiff or the defendant can ask the court, sir, please examine a particular court witness. మీనింగ్ ఆఫ్ ది కోర్ట్ విట్నెస్ కోర్టు కావాలనుకుంటే ఇప్పుడు మీరు ఎగ్జామ్ నీ విట్నెస్ ఎవరైనా విట్నెస్ కావాలంటే నీ పక్క ఎగ్జామ్ చేసుకో, లేకపోతే వదిలేసేయి. అంతేకాని కోర్టును అడగవచ్చా కోర్టు విట్నెస్ కా? ఎస్, దెర్ ఇస్ సచ్ పవర్. అట్ ది ఇన్స్టెన్స్ ఆఫ్ ఎ పార్టీ, సార్ పర్టికులర్ విట్నెస్ ఇస్ దేర్, దో ఐ summon him, though I find a petition summon, he will not come. Even if he comes, you don't support me. So under those circumstances, if it is brought to the notice of the court, but particular evidence of the particular witness is necessary, such witness can be examined as a court witness. Both plaintiff and defendant will get right to cross-examine, and he should obtain permission, formal permission from the court. Court witness can be examined. Number of citations are there. Mohan Reddy versus Rebba Pedda Agaya. Pelosal Pedda Reba REBVA Rebba Pedda Agaya AGAIH 2008 NOC notes of recent cases 127. Again
1217.
in the 1217, right? Correct. In the 1217 నేను తప్పు చెప్పాను. In the 1217 ఉందా? రైట్. అట్లాగే 2012 వాల్యూమ్ 2 ALT 675, 2012 వాల్యూమ్ 2 ALT 675, DK Narasimha versus Renuka Devi. DK Narasimha versus Renuka Devi. Another judgment in this regard is P. Subramaniam Chetty versus Katari Yellappa Reddy. 1988, volume 1, ALT 279. 1988, volume 1, ALT 279, wherein the lordship held that court can be examined. Now the question is whether the appellate court can examine any particular witness as a court witness. First appellate court, whether the first appellate court can examine a particular witness as a court witness. Trial court, no doubt. Appellate court, first appellate court. మీకు ఖచ్చితంగా ఫైన్ వేయాలమ్మా.
Yes,
ఎట్లా?
sir, and the same powers are.
Good. What is 107 CPC? Already we have discussed. 107 CPC, all the powers that are conferred, all the duties that are conferred to a trial court. The first appellate court is also. First appellate court is a fact finding also. Okay. Then right. These are the 12 matters I want to discuss with you. In fact, with a practice in regular practice in advocate, because all these aspects are different judges are feeling, different advocates are feeling different opinions. Only for them, these are the relevant. There are other questions also, only 12 questions for the day I have selected. Okay? Right. అయిపోయిందని 10 నిమిషాలతో పోయింది అయింది. నేను కొన్ని బ్యాగ్ సర్దుకొని స్టేషన్కి వెళ్ళిపోతే టైం అయిపోయింది. యాక్చువల్ ప్రాక్టీసింగ్ అడ్వకేట్ వచ్చిందంటే మొత్తం ప్రతి సైటేషన్లో వ్యూ ఆఫ్ ది ఆనరబుల్ హైకోర్ట్స్ ఎక్స్ప్లెయిన్ చేసేవాళ్ళు. ఇది కూడా రికార్డ్ అవుతుంది, వేరే విషయం రికార్డ్ కానీ ఇప్పుడు నేను అనంతపురం జిల్లా కళ్యాణదుర్గంలో చెప్పాను, హైదరాబాద్ సిటీ సివిల్ కోర్ట్ చెప్పాను ఆస్పెక్ట్స్, దెన్ కర్నూలు డిస్ట్రిక్ట్ ఆర్లగడ్డలో చెప్పాను ఇవే ఆస్పెక్ట్స్. అక్కడ మొత్తం 6 hours చెప్పాను ఆర్లగడ్డలో. there are other aspects also there. So want of time in 1 hour 20 runs Sachin Tendulkar ante in na paristhiti. Okay, see you, all the best. Back some good station on top time. డైరెక్ట్ గా టెన్షన్ పెట్టారు 42 వెయిటింగ్ లిస్ట్. పొద్దున వరకు కన్ఫర్మ్ కాలేదు, ఇప్పుడు కన్ఫర్మ్ అయింది.
Hey.